This is Fighting for What's Right with personal injury attorney Barry Doyle. So Barry, once you've figured out what the fair settlement value of a case is, how does the case get settled?
Well, as a starting point, you need to make sure that the insurance company has the materials it needs to evaluate the case on their end. And typically that'll include things like your medical records and your medical bills, as well as any kind of supporting documentation like photographs, witness statements, a police report, things of that nature. If the case is in suit, those things get turned over to the defense lawyer as part of the pretrial discovery process, and it's up to them to transmit that stuff onto the insurance company. The bottom line is the insurance company has to have some type of a basis for making you an offer. The adjuster isn't going to offer you any money without a reason for doing so.
So after the material is put together, how does the process get started?
It almost always gets started with the injured party making a settlement demand.
Why did they go first?
Ultimately, the case is under your control, and it's up to you to decide how much money you want to settle it. The insurance company is also happy to have delay built into the case because how they make money is by taking premiums, investing in the stock market or real estate or junk bonds or whatever is profitable for them, and then paying out as little in claims as possible. The other reason that they look for you to make a settlement demand first is they have their own internal valuation as to what they think fair settlement value of your case might be, and they would be really happy to see you underbid that.
All right, so how much do you ask for?
It's a funny process because once we hit upon what's a fair range of settlement values, it's almost a little like selling a house, but different in one big way. If you're selling your house and you want $100,000 for your house, most often you'll put your house on the market for, say, $110,000. And if you get 103, you're going to be pleased as punch. Now, if I want to settle my case for, let's just say, $100,000, the practice in our field is that if you want $100,000, you start off asking for a number that's way in excess of that, like $275. Why that's the case is something that's never made a lot of sense to me, but it is what it is. And if I had wanted $100,000 and started off at 110, the insurance company is going to look at that and think, well, he really wants 40 or 45.
When does a settlement demand get made?
The operating rule in my office is that we don't start thinking about settling a case until you're either all better or as good as you're going to get. In other words, that you have made a full recovery or you've made as full a recovery as you're going to make from whatever injury it is that's at issue in your case. Because the nature and extent of your injury is one of those three key variables that we talked about earlier in terms of evaluating a case for settlement. I don't begin to think about that until I really know what the answer to those questions are. Now, when that point comes is going to vary from case to case. Some cases are suitable for pre-suit resolution, others really aren't. And there are going to be opportunities all along the lifeline of a case from prior to suit being filed to all the way up to the case has been tried and is up on appeal, where it may be a good time to discuss settling a case.
So how do you come to a point where the case is actually settled?
Ultimately, you have to get to a number where the client is willing to accept it and the insurance company is willing to pay it. There's no process by which anyone can be ordered to accept a settlement or to make a settlement offer that's not voluntary. There are a number of processes that are used to try to reach that point where they're willing to pay a certain amount and you're willing to accept a certain amount. One of these is mediation, where you have typically a retired judge or another lawyer act as a mediator to help people reach that middle point. Occasionally there will be judges who will be willing to act as a mediator in what's called a pretrial settlement conference. But those are generally the types of things where essentially you're bringing in a third party to help you reach that point of resolution. The one thing that you need to keep in mind is that these negotiations are sort of a one-way ratchet. In other words, once you reduce a settlement demand, there really isn't grounds for increasing it at some point down the road unless there's some type of change in circumstances that really justifies it. And simply the fact that the case has gone on, that you've incurred more case file expenses, is not the kind of justification that you want. So you want to be very careful as you make these moves downwards from where your initial demand is to eventually reach that point where they've offered money that's within your settlement range.
So while these discussions are ongoing, what's the client's role in all this?
Well, the important thing to keep in mind about this is, lawyers have an ethical obligation to inform clients about any type of settlement offer that's being made, even if it's one that, as a lawyer, I'd never recommend to the client. In the end, it's the client's case, it's the client's life, it's the client's decision, regardless of whether or not I personally agree with it.
Okay. This has been Fighting for What's Right with personal injury attorney Barry Doyle. Feel free to check us out online at fightingforwhat'sright.com, like us on Facebook, and also subscribe to our YouTube channel.